Maneva na se ma PENDREAM TV. PENDREAM TV de o se dem yopo.
Na alayi mama unchan ya. We ye emranimu ni lawyer, astute one. De akoso na Supreme Court di ruling aba per the appointment you de call you know eto say
because when see I see how the Supreme Court is taken to do an indirect means what cannot do
you be law adini my kakra bibi wachi
me tell ka work already so you
okay bachi you me too
so I did me can say I was quite taken aback because what the Supreme Court Supreme Court now is trying to do indirectly what it cannot do directly.
Which you say
Supreme Court any to me to interfere in the internal workings of Parliament. Supreme Court susu a creature of the Constitution into a one jurisdiction. Now the Supreme Court jurisdiction is not at large. That is not the jurisdiction of the Supreme Court.
It matters in respect of say you will be declare seat vacant no. Speaker also does it lie in his power?
Yes. Article 97 vests that power in the Speaker. So it doesn't lie with the Supreme Court. In fact, the nearest a court can declare a seat vacant is in Article 99, where there's a challenge to the election of a member of Parliament. Then the High Court, if it comes to the conclusion that that member of Parliament was not validly elected, can declare that seat vacant.
Yeah, 99 A.
I'm just telling you, let me catch you say the nearest jurisdiction of the court to declaring a seat vacant is in Article 99.
But whereby Obiaba seeking for interpretation.
Interpretation is a different thing than declaring a seat vacant. Declaring a seat vacant is within the preserve of the Speaker of Parliament.
Article
97.
Article 97, Mami, me Article 97G, and our kana. I'll say, my preamble. A member of Parliament shall vacate his seat in Parliament. G. If he leaves the party of which he was a member at the time of his election to Parliament to join another party, or seeks to remain in Parliament as independent, or he was elected a member of Parliament as an independent candidate and joins another party. Now, Mami Musa, they took a legal step. Now, Muhammad Moka or the uttering pattern rule. It didn't speak no one. One tier man masem. Two.
The Supreme Court is totally wrong.
I don't know.
No, you don't need to go there.
Okay.
I'm telling you that the Supreme Court is totally wrong.
Why?
In Article 97.
Okay.
The same Article 97, where the drafters and framers of the Constitution intended that before the declaration of a seat vacant, the Speaker must listen to the other party. The framers have provided it in Article 97. Article 97, where the framers were of the view that before the declaration of a seat vacant, the Speaker must listen to the other party. They provided it in that Article 97. And you know the case of Ajua Safo. One of the grounds that Parliament can declare a seat vacant, the Speaker can declare a seat vacant, is when a member of Parliament absents him or herself for 15 sitting days without the permission of the Speaker, and without a reasonable explanation to a committee of parliament.
Honorable,
you see, what make cancer provisional extra amount for you now is under Article 97.
Article 97 G.
No, not G. Article 97, I think C or so, where the
okay, my man can Article 97 1C was say a member of parliament shall vacate his seat in parliament C if he is absent without the permission in writing of the speaker and is unable to offer reasonable explanation to parliamentary committee on privileges for 15 seconds of a meeting of parliament during any period that parliament has been summoned to meet and continue to meet, or if he is expelled from parliament after having
no.
Okay,
I just want that one. The person who said the same Article 97 provides for the speaker to listen to the other party, the rules of natural justice to apply.
Sure.
In that provision, but doesn't apply for others. For instance, where a person has resigned by his own writing as a member of parliament, does it provide that the speaker must listen to the other party?
No.
Where a person has died, does it provide that the speaker must wake that dead person up?
No.
So what are they talking about?
Papa, Mami Musadio, party I want belong to no.
So the Supreme Court is wrong, totally wrong.
Papa, Mami Musadio, party I want free moon. Where expression of intent. Senior parliament, your parliament where I still remain with my party. Name of the next parliament, I will not remain with them.
So there are 2 reasons or 3 reasons why that intent is consequential. 3 reasons. Number one, the Speaker Michael Quay in 2020 November ruled that Andrew Esiama, now on the MP on the ticket of MPP in Parliament. Now, you pre-election 2020, offering Parliament, offering the party, echo contested as an independent member of Parliament. The party petitioning the Speaker, invoking constitutional provisions and expelling Andrew Esiama from the party. Every say on the party no view. He had lost that position as a member of parliament because member of parliament is an office of the party. The which party so that's why that member of parliament is sponsored by the party. The who need party no view. You are taking an action or you are engaged in activities that is inconsistent with the party's philosophy and ideology. You see, won't mean continue to occupy that office of a party when you are doing things contrary to the party. And immediately you lose your membership of the party, you have to lose your membership of parliament.
Papa, yeah, can say
that's number one.
Okay.
Number two, Supreme Court, Makoke ma ruling no 4 years ni Obiara iron challenge. Number three, Article 97(2), 97(2)(c), notwithstanding the provisions in Article 97(1)(g) and (h), no, if there is a coalition in Parliament and a member of Parliament from another party sits with another party for the purposes of conducting business, and that is allowed and sanctioned by the party, that person will not be said to have crossed carpet. So, when Andrew Esiama came to Parliament as an independent member of Parliament, he chose to sit with the MPP and Anyasa.
Sanity.
Did they declare his seat vacant?
No.
But that was a future intention that actualized in Parliament. Not so.
Papa,
he chose.
In law.
Number three, Miba.
Okay.
Number 3, when a speaker rules under Article 97, 1G and H, that ruling is based on the understanding by the speaker of the implications of Article 97, 1G and H. But that ruling is subject to interpretation in court. So if you go to court for an interpretation, that is not an interference in the decision of Parliament. That is seeking a clear authoritative interpretation of that provision. Because here, every day we are interpreting the Constitution to guide our activities. But it is only the Supreme Court that can provide an authoritative interpretation. Wow. So when you go to court for an interpretation, it doesn't operate retroactively to affect everything. So if you interpret the Constitution, this is the position of the Constitution, it will, and that the Makokwe was wrong in sacking in this from Parliament. That will not operate to bring back Andrew Esiama to Parliament, because that Parliament is gone. So the fact that the MPP went to court for interpretation is not mutually inconsistent.
Now, honorable, my musa question you know the FM common maybe. One.
But
okay.
Me say me nua
obi wine
or certificates. Me say obi wine. You are a respected member of the bar. Don't be mentioning cases by heart. Because what is the Zenoto case? What is the Zenoto case? What was the locus decidenda of the Zenoto case? The Zenoto case sought to answer when it's a person said to have filed for Parliament, to be eligible to file for Parliament. That was the question the Zenoto case was answering. It was not answering whether or not the Supreme Court can stay the hand of Parliament. It was not answering that question. So don't be mentioning cases and certain cases for what? Because you confuse the public and you fail to do justice to the matter. Hello? Hello?
I want to meet you.
And you remember Minimuka interview in the Asen North case. You remember?
Yeah, I'm a cousin of Jachikwesi.
And I told you that the Supreme Court was processing a jurisprudence of convenience. Okay.
Okay.
Well, okay. And people insulted me proper. Okay. Okay.
And the said, yeah, no crabby or alcohol can't the other down, baby.
You see, when I said that as a lawyer, I saw convenience, jurisprudence of convenience in the decisions of the Supreme Court. Me say in that question, Supreme Court say that question should not go to Parliament. Okay. Nothing enough for now omunya nipa ana. No more here representation. No more here representation. I don't think the Supreme Court will say that the question more on go Parliament until the determination of the case. The same Supreme Court too. Okay, Centrophy, Apafo, le lobby, and le pays, okay, 4 years, 4 years, a suit is lying at the Supreme Court, 4 years. Okay. Now, enclave, no. Omun here representation.
I see. Now, honorable.
Then the Supreme Court is not saying that by reason of the fact that some people will lose representatives in Parliament, the people should go. This is clearly jurisprudence of convenience.
And no, yeah, one of the grounds. Now, I don't know, Mami Musadio. Speaker, did he take the pains? So, Fred, the affected members of Parliament, say, no cross, more expressive this intent or legal step 2 mo party ni mu ana mo afimu
minua
alaji
minua ma dika country say constitution under article 97 can nyina
me
demonstrated to you say where the framers of the constitution intended that those people be called and asked, it provides it.
Papa, de tia me busa sa no say e bi kwa obe frɛ no no obaka se mpa cha wo me nkwa gina ba bia
and to me ben so as you ask the question Mr. Wendras is how not to me ben did the speaker have to call the people.
Okay.
Because in
based on rules of natural justice
Article 1971C, if the speaker declares a seat of a sitting member of parliament vacant on the basis of absence from parliament with a reference to the committee on privileges, that decision will be unconstitutional.
I see. Now, Baba Mami, we are there. We per the Supreme Court ruling. Matisa and Ransono, NDC, Kokosuno, I meeting said they will not be binded by the ruling of the Supreme Court. Now, and no, they didn't say, and I say, I'm not directly speaker. Speaker, I'm fair, would that?
How can the Supreme Court direct the speaker to allow that? How can the Supreme Court do that? You have arrogated to themselves powers they don't have. Without not have powers infinitum, ad infinitum. The Supreme Court doesn't have it. They don't have that power. The speaker.
Say, I'm fine, Yagma. Yes, you mean cited the speaker for contempt.
The Supreme Court should even be cited for contempt of parliament. Parliament has taken a decision, and then you sit down as Supreme Court to superimpose yourself on parliament and direct parliament how to perform its functions. What to be that?
So there will be legal chaos.
They have provided the legal chaos. They should have concerned themselves. Supreme Court should have concerned themselves with interpreting the Constitution. That's their jurisdiction.
I see.
That's their jurisdiction.
Edi Ochinano says speaker and fine Juma.
Speaker and fine Juma.
Wow.
Because that will be subordinating parliament to the Supreme Court.
Nana,
they're independent arms of government, for God's sake.
But
that is what democracy is all about.
But Supreme Court, you know, so one more, they are there to do the checks and balances.
But parliament too is there to do the checks and balances.
Wow.
And the people are there too to do the checks and balances. We the people decided to establish a Supreme Court and vest it with specific jurisdiction. Example, the Supreme Court has no speculative jurisdiction. So when the Supreme Court says that government business will run into chaos, they're invoking a jurisdiction they don't have.
Okay.
It's speculative.
Yeah, okay. Alaji, mami na wase no pe wati.